This is Michael Popok, Legal AF. Judge Chutkan has gagged Donald Trump once again. You heard it again, folks. Judge Chutkan ruled just hours after Donald Trump completed the final brief in the case, his reply brief, which was filed on Saturday. And by Sunday night, without a hearing, we have the order of Judge Chutkan. Judge Chutkan has ruled that she is reimposing the original gag order that she placed on Donald Trump on the 17th of October, and that she is therefore not going to continue the stay of the gag order, which she had administratively imposed for a short period of time to let the parties be heard about whether the stay should stay in place, and the gag lifted all the way through Donald Trump's appeal of the issue at the D.C. Court of Appeals. But now, having read the briefs and read Donald Trump's arguments, the judge is like, well, we're going back to the gag order now. Now, let me remind everybody where we're at, and then I'll give you as much information as we presently have about the new order. We know that it's in place, and I'll try to give you my best guesstimate as to the contours of it. 17th of October, after full briefing and a 2-hour hearing in front of Judge Chutkan issued her opinion and order, which we refer to colloquially as the gag order. And what she said was the following, and then I'll talk about why she stayed that order and why she is lifting the stay and reimposing the gag order now. All on this hot take. Just bear with me. I assure you we will get through it in due course. On the 17th of October, the Judge Chutkan wrote as follows on page 1. Under binding Supreme Court precedent, this court must take such steps by rule and regulation that will protect its processes from prejudicial outside interference. The First Amendment, the court goes on, does not override that obligation. Freedom of discussion should not be given the widest range compatible with the essential requirement of the fair and orderly administration of justice, but it must not be allowed to divert the trial from the very purpose of a court system to adjudicate controversies, both criminal and civil, in the calmness and solemnity of the courtroom according to legal procedures. For instance, on several occasions, this court has approved restriction on the communication of trial participants where necessary to ensure a fair trial for a criminal defendant. The court went on to analyze U.S. Supreme Court precedent and the alleged conduct of Donald Trump, including his attacking individuals involved in the judicial process, including, in her words, potential witnesses, prosecutors, and court staff, and his publicly targeting for harassment and other intimidating effects during the pretrial and trial stages of this particular case. And so the court entered the following as her gag order. This is the actual part of the ruling that's the gag order. It has ordered all interested parties in this matter, both sides, including the parties and their counsel, are prohibited from making any public statements or directing others to make any public statements that target, 1, the special counsel prosecuting this case or his staff, 2, defense counsel or their staff, 3, any of this court's staff or other supporting personnel, or 4, any reasonably foreseeable witness or the substance of their testimony. And then she clarified it with a, to clarify, if you will, commentary about her own order. She said, this order shall not be construed to prohibit defendant Trump from making statements criticizing the government generally, including the current administration of the Department of Justice, statements asserting the defendant is innocent of the charges against him, or that his prosecution is politically motivated, or statements criticizing the campaign platforms or policies of defendant's current political rivals. So she gave a for avoidance of doubt so that he understands. And Donald Trump, since the 17th of October, has gone right along campaigning and attacking whoever he could that's not related to this order with his base. That's obvious. And so the briefing that went on happened because Donald Trump asked last week for the judge to do a temporary stay of her order and lift it so it wouldn't be binding on Trump to allow Donald Trump to appeal it to the D.C. Court of Appeals, which he'll do. You have 2 places to get your stay if you want to get your gag order or your order lifted. 1, you ask the trial judge to do it. Failing that, you ask the appellate court to do it. And there'll be an administrative judge of the appellate court who will decide whether there should be a stay or not, pending the full adjudication of the issue with the merits panel, the 3-judge merits panel of the court. So he went properly this time, Trump, to Judge Chutkan and said, "Won't you please lift your gag order for now while I take the appeal?" And the judge, because she's very sober and she's very reasonable, she said, "I think this is an issue that needs full briefing. So for now, I am going to temporarily, administratively stay my order for this short amount of time, like a week and a half. And I want full briefing. And I want the government, the Department of Justice, Jack Smith, to file his brief this past Wednesday," which he did. "And I want Trump to file his brief by Saturday night," and he did late on Saturday, but he got it in on Saturday night. And we know how fast and the velocity at which Judge Chutkan makes her rulings. She makes her rulings quickly. I even predicted on Legal AF, our podcast, that she'd be ruling probably without a oral argument. And so that was Saturday night, full brief. Now it's fully briefed. Federal judges generally make rulings without oral argument. They don't need a hearing. They already had a two-hour hearing last time, and nothing really changed except in the papers that were filed by the Department of Justice on Wednesday. They were up to the minute. They were outlining for the judge all the places where Donald Trump has continued to attack people violently since she lifted her gag order, right? Including his attack on Mark Meadows, who's now been identified as a key witness for Jack Smith. And he virulently attacked Mark Meadows. And then all the other people who are scared of Donald Trump and his free speech, including the 60 Minutes Australia piece, which we ran on the MeidasTouch and Legal AF networks here, about Anthony Pratt, the billionaire like Trump of Australia, who was secretly recorded and said Donald Trump operates like a mobster. And so they were putting in real-time things that had just happened that day, like Donald Trump violating the gag order for the second time in New York in the hallway. That Wednesday ended up in the Department of Justice's papers that Wednesday when it was filed. That's how up to the minute it was. And then the opposition or the reply paper that got filed by Donald Trump late last night, which we have a copy of, was really not a reply paper. A reply paper is supposed to be what it sounds like. You reply point by point to the arguments raised by the Department of Justice, and you cite to them on page blank of the motion or the order or whatever you're responding to, and you refute them. What you're not allowed to do is repeat and regurgitate what you did in your opening brief, which is exactly what Donald Trump did. Here's the argument Donald Trump told the judge as getting the last word in the motion practice. He said, "Everything I say right now, because I am the leading candidate for the presidency," his words, not mine, "is core political campaign speech that cannot be restricted any way, shape, or form." That's their argument. The argument is because he is currently a candidate, through a feat of alchemy, it converts everything that comes out of his mouth into core protected First Amendment speech that knows no limits and knows no boundaries and can't be restrained, even though there's this thing called the criminal justice system and the other branch of government laying right next to it. He's saying you can never map a gag order onto me because I am the candidate. This is what Donald Trump always believed when he decided to run for office, that it would somehow put the kibosh on all of these prosecutions against him. And so, but that's not the case law. And the judge had already, in her order, had already cited case law that stood for the proposition that there are two rights under the Constitution that are in conflict here and have to be reconciled. The First Amendment right of somebody in core political speech, yes, but the Sixth Amendment right to have a fair trial, a fair and impartial trial, and the administration of justice, and not having that system overturned, if you will, or attacked or pressurized by the person who's the defendant, is important as well. It's an important principle of our system of government. And so there's plenty of cases that say that there is a threshold across which you cannot cross if you are using your First Amendment rights, because it interferes with the fair adjudication or fair administration of justice. And that's what this Judge Chutkan has said time and time again. his First Amendment rights running for office don't matter to me, except up to the limits of what he's allowed to do without interfering with the proper administration of justice, which is my job. She keeps reminding Donald Trump, because he keeps forgetting, and his lawyers, that Donald Trump and his liberty is at her discretion. And it is in her hands, that he is an indicted 4-time felon in the federal court system in front of her. And therefore, his freedom is being administered by the criminal justice system. And so there are limits of what he can say outside the courtroom. And it's clear, as the papers for the government, the Department of Justice, laid out, it hasn't inhibited him at all in his ability to campaign. He wants to attack the Department of Justice, great. Joe Biden controlling the Department of Justice, have at it. Judge Chutkan kind of generally, without violent rhetoric against her or racial attacks, maybe. He can do all of that. He can say he's innocent, but he can't attack and target witnesses like Bill Barr. We'll put up something here. He's already in violation of the gag order as of the time that it hit the docket today. The judge just hit the docket again with this, and we're waiting for the full order. What we have for right now, that I can read to you is what's called the docket entry, which alerts lawyers and people that follow things like this that there is an opinion and an order coming, but she wanted it clear that it was on the docket. And it was docketed at 7:05 p.m. Eastern time today on Sunday night. It says opinion and order as to Donald J. Trump denying defendants a motion to stay pending appeal and lifting the administrative stay imposed by the court's October 20th, 2023 minute order signed by Judge Tanya S. Chutkan. We're still waiting to get our hands on the actual order to see what she wrote, because I'll be frank, the electronic docket crashed. This order or other things like it broke the internet, at least the court internet, and we're not able to get our hands on it. We will, I promise you. But we already can pretty well guess. 32 years of trial experience in courtrooms just like this one. Legal AF, our leading podcast, we do this all the time. So we are not shocked by the result here. We would have been shocked had Judge Chutkan, based on all of the briefing in front of her, this ridiculous argument that by Donald Trump that everything and anything he says is core political speech that can't be regulated in any way whatsoever. I mean, that's the same approach he took to the trying to overturn our election system and our electoral system. He's trying to flip the apple cart on our court system and our judicial system, and that he's not allowed to do. The other thing they had argued is that the gag order, which I read to you, is very, very simple, in plain English and easy to understand, was actually incomprehensible and overbroad and vague. They couldn't figure out what it meant. They said they don't know what some of these words mean, Judge. Some of the words were like, we don't know what rhetoric is, and we don't know what violent is, and we don't know what target means. I mean, it was really silly. And I think the judge was waiting to see, all right, maybe they'll grow a brain between their first filing and they get the last word here on the Trump side. Nope, they didn't. It's the exact same regurgitation of what they wrote the first time around. And so she is now confident that there is a full record that can go now up to appeal to her bosses at the D.C. Court of Appeals. She's appealed, but she's frequently upheld. She's a well-respected trial judge. Probably will be on the D.C. Court of Appeals one day, especially if Biden has his way. Could be on the U.S. Supreme Court one day. She's that well-respected. And so she's basically said to Donald Trump, have at it. You got a full briefing now. You got my order, 2 orders. You got 3 briefs, full record. Take that up to the appellate court. So they now, this is very key. Rather than it being completely sua sponte, meaning at the appellate court level, they're making their own decision based on, some record in front of them and some briefing schedule. They now have a set of briefs in front of them, and they have to use what's called an abuse of discretion standard, which is to the judge's advantage here, because it is very hard to overturn things that are an abuse of discretion. And even though the other side will argue for a heightened standard to evaluate her order, I don't think there's any other way to read this based on now the full record is that the appellate court is going to have to decide whether there was an abuse of discretion, which is a very low threshold. In other words, judges are given tremendous amount of discretion at the trial court level to make decisions. And to overturn that, you have to show what's called an abuse of their discretion, which is very difficult for Donald Trump to make out. So this, again, is another way that Chutkan cornered Donald Trump, made him brief the issue here in the trial court level, and then he can't start all over again with new briefing or new issues. It's now going to be them evaluating the stay and whether the stay should be lifted or not. Another brilliant position by Judge Chutkan, and then, of course, the Department of Justice worked right with it. We'll get the actual order. I expect the internet will log back on later tonight or early tomorrow. We're looking for it. We're refreshing all the time, trying to get our hands on it. But the docket entry told us everything we need to know. Donald Trump has lost. He's lost his bid to have his gag order lifted. He's already in violation of his gag order, having gone after, for instance, Bill Barr. He's going to have to sit down with his lawyers and understand as of 7 o'clock tonight what he can and can't do. Because if he violates it again and crosses that line in the sand, this judge is going to bring him in for a contempt hearing and require that he be there and be under oath. And then she's going to go from there. It may start at a fine, but this will very rapidly go to jail time. Now, John Lauro, the lawyer for Donald Trump, has let it be known that he doesn't think that the judge will ever really impose the gag order on Donald Trump, and nor will she put him in jail. I got news for John Lauro. I don't know what game you think you're playing with a federal judge, but I would not play that game. This is even Judge Engoron in a civil context in New York is progressively moving you towards potentially finding you in contempt and perhaps putting him in jail. And then it'll have to go up on an appellate process. I would not play with a federal judge, not one who's now reimposed the gag order after listening to the full briefing, who has the support and often is affirmed by her bosses at the Court of Appeals. I would not play with that at all. But we'll see what John Lauro and Donald Trump do. They like to test the limits of things. I got impeached, but will I get convicted? I led an insurrection, but will I be, banned from a ballot on a certain state? I mean, he's constantly pushing and testing and probing to find the limits of what the system will allow him to do. We'll continue to report on gag orders and their violation and what happens to those gag orders right here on the MeidasTouch Network on this YouTube channel. You knew that. You know where to find us. I do a hot take like this. Some days it seems like every hour I'm doing a hot take. At least once a day, I do a hot take at the intersection of law, politics, and justice. And then we kind of pull it all together and curate a podcast, which is the leading podcast of its type, only on the MeidasTouch Network, exclusively there, called Legal AF. It is what you think. And it's every Wednesday and Saturday on 8 p.m. Eastern time, and then on audio platforms wherever you find them. And then if you like this kind of content, give me a thumbs up, leave me a note. Sometimes I respond to it if I see something very interesting. And then you can follow me on all things social media at MS Popok. Until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.